Hello, everyone. This is Tom Fox. I'm the Compliance Evangelist, and I'd like to welcome you to this special 5-part podcast series sponsored by Affiliated Monitors, which celebrates Affiliated Monitors' 15 years in business as the first entity specializing in independent integrity monitoring. Founded in 2004, Affiliated Monitors provides independent integrity monitoring and ethics and compliance assessments nationally and internationally and across almost all industries. With its knowledge of effective ethics and compliance programs and cultures, Affiliated Monitors is respected for its work as the corporate monitor on matters ranging from multinational corporations to small and mid-sized companies and even individuals. Having served in nearly 750 monitorships, no one has more experience as an independent monitor than the team at Affiliated Monitors. For more information on how an independent monitor can help improve your company's ethics and compliance programs, visit this podcast series sponsor, Affiliated Monitors, at www.affiliatedmonitors.com. In this 5-part series, I visited with Jerry Coyne. Jerry is the Managing Director of State Monitoring Services at Affiliated Monitors. We consider the use of monitors by state attorneys general. In Part 1, we take a look at the role of state AGs as enforcer. In Part 2, the reaction to the big tobacco settlement and criticism of state attorneys general. Part 3, the multi-state settlements in the post-tobacco era. Part 4, challenges of multi-state litigation today. And Part 5, we take a look at the road ahead. It's a fascinating series. I know you will enjoy it as much as I enjoyed bringing it to you. In this episode 3, we consider multi-state settlements by state attorney generals who have banded together for litigation in the post-big tobacco settlement era. This special 5-part series is a special presentation of the Compliance Podcast Network. Hello, everyone. This is Tom Fox, back again for Part 3 of our 5-part exploration of the use of monitors by state's attorney general. In this, I'm joined by Jerry Coyne, the Managing Director of State Monitoring Operations at Affiliated Monitors. Jerry, welcome back.
Thank you, Tom.
So, Jerry, I'd like to take up the topic of multi-state settlements in the post-tobacco era. So we've been talking about extensively big tobacco, the litigation, and the settlement that came up with big tobacco. So I was wondering if you might start with some of the challenges that state's attorney general found they had, and really how industry leaders did not want to be the next tobacco.
Well, that Tom, was a phrase we heard over and over again. Who would be the next tobacco? And at different times, there were different industries identified as who it may be, but I don't think we've had anything of that scope since. Nevertheless, there have been a lot of different challenges out there to, aspects of the tobacco case that were used. One of which was that, like we've talked about before, the use of outside counsel. The use of outside counsel was really something that you heard about widely criticized, particularly by groups like the U.S. Chamber of Commerce and some others. And there were many, many efforts to prevent attorneys general from having that power going forward. And one of the ones that was actually litigated and made its way to a state Supreme Court was one that came out of the state of Rhode Island involving lead paint.
The use of outside counsel, having been an outside counsel myself, I always felt like I could bring not simply resources, but a skill level that perhaps was not available to a state attorney general. Did that consideration also play a part in the state attorney general calculus? Absolutely.
And I think, Tom, to be fair, you're exactly right. Outside counsel have the ability to bring both resources and skills. I think that there are some extraordinarily talented attorneys in state attorney general's offices, but when you start talking about, like you say, national level litigation, there's a set of pressures on that. There's a set of just what it takes to prepare for it and manage that litigation that attorneys general's offices just don't have those resources to do. So you need help. In the same way a police or fire department can call for outside resources, that's the way we traditionally viewed outside counsel, that it allowed us to bring in extra help in a specific case. The challenge, though, was really not could you bring somebody in, but how were you going to pay them? And the argument was that if you paid somebody on a contingent fee basis, then you took away what was supposed to be a search for justice by the Attorney General and replaced it with what they used to refer to as just being a personal injury lawyer. The argument was that contingent fee counsels were simply motivated by money as opposed to a state attorney general's office that should at least have a more noble purpose in terms of looking for justice.
What were some of the defense considerations you heard, Jerry?
Aside from the defense counsel, which I think, the use of outside counsel, which I think there was some merits to on both sides, one of the real concerns that people brought up was this idea that civil litigation was now going to be used to target industries simply in order to balance budgets. And that people were finding was that there was more and more pressure being put on the state attorneys general now to come up with money that would be able to be used for that purpose. And there were a few actions in the beginning where that became very clear, and what the defense community really started to try to do was to move towards a more restrictive use of those funds.
Jerry, I'd like to turn now to some of the post-big tobacco actions and ask you a little bit about some of these. And one of the first ones I remember was the car tires action.
You know, Tom, if you remember, it was Firestone tires, which were historically one of the better brands of tires that were out there. It was a national brand. A lot of people used them. And shortly after the tobacco settlement, there was some situations, particularly in the warmer climate states, where Firestone tires had begun to blow out on cars without any warning. And as a result of that, a large number of states gathered together and actually sued Firestone tires under the State Attorney General's Consumer Protection Authority. And Firestone was preparing to settle, but their concern was all of the states had not yet joined that action. And that caused what Firestone ended up doing for the very first time, the states that had not participated in the suit originally, and there were a number of attorney generals that had not, all of those states were invited to join the settlement before it became final. So whether you had participated in the original litigation or not, you still had an opportunity now to join the settlement, which resulted in monies coming to the state, but more importantly for Firestone, it gave them closure.
Jerry, after the 2008 financial crisis, I think many people looked at the mortgage industry as, if not causing it, perhaps contributing to that financial crisis. Was there a large state's attorney general effort aimed at the mortgage industry as well?
I think, Tom, the national mortgage litigation was probably the closest thing we had to the next tobacco until very recently. In 2012, there was an agreement between the nation's 5 largest mortgage servicers. The 5 mortgage services that were involved in that, which were Ally Financial, Bank of America, Citigroup, JP Morgan Chase, and Wells Fargo, serviced over 60% of the U.S. mortgage market. What was interesting in that case was that those 5 mortgage servicers were never going to go out of business, even though, like I said, in tobacco, there was some sense that perhaps the litigation could be used to put the tobacco industry out of business. Nobody expected that those groups were ever going to go out of business as a result of the settlement. But it was ultimately 49 states and the U.S. Justice Department participated in that settlement. Again, probably the biggest settlement that came in the post-tobacco era.
Jerry, one thing that's on everyone's mind now is the opioid crisis and the attendant litigation around that. Seems to be a huge case going on, actually, as we're recording this in the state of Oklahoma. But I was wondering if there have been any other post-big tobacco actions regarding Big Pharma.
Absolutely. I mean, as to your point, they're going on all over the country now. There's a multi-district litigation, which is centered in Ohio, that involves a number of suits that have been brought together. There's the Oklahoma case and a number of others. And then there's other cases also involving pharmaceuticals and specifically price fixing among the generic pharmaceutical manufacturers. But what distinguishes, I think, pharma here, and I say pharma, the pharmaceutical suits, is that nobody wants to put the pharmaceuticals out of business because what they make is a critical product that many people not only want, but many people medically need. The desire here is to allow them at the end, I think, to emerge, but to emerge following a new set of rules and making sure that they actually adhere to those rules. The arguments from the states are that the actions of the defendants in all these cases have certainly caused damages, but at the end of the day, I think people would much look towards a settlement as in tobacco or the mortgage cases that allows the companies to emerge, but emerge with a new way of doing business.
Well, Jerry, where do you think, or what do you think the future holds in this area?
One thing we have learned is that money damages are not enough. If there was a theory historically that if you simply took away a company's financial incentive to break the rules or do something they shouldn't, the businesses we're talking about here, tobacco, the big banks, and the pharmaceutical companies, or at least some of them, we are talking about industries and businesses that have been so profitable that taking away money is not going to be enough to change behavior. And so what people have to look at as a lesson from tobacco and a lesson from these other cases is that what you need to do is ensure that in addition to money changing hands to pay for the damages, you find a way to regulate those businesses going forward so that the conduct does not get engaged in the future.
Jerry, unfortunately, we are near the end of our time, but I've been visiting with Jerry Coyne, the Managing Director of State Monitoring Operations at Affiliated Monitors. I hope you'll join us again tomorrow where we take up some of the challenges of multi-state litigation today. Jerry, thank you so much for taking the time to visit with me.
Thank you, Tom.
Hello, everyone. This is Tom Fox again. I hope you've enjoyed this episode of our 5-part exploration of the use of monitors by states' attorneys general. If you need more information, check out the Affiliated Monitor website, www.affiliatedmonitors.com. I hope you'll join us again for another episode in this fascinating 5-part series. I know you will enjoy it. This special 5-part podcast series on the use of monitors by states' attorneys generals is a special presentation of the Compliance Podcast Network.